a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. Roe v. Wade. Roe v. Wade, 410 U.S. 113, is a landmark decision issued in 1973 by the United States Supreme Court on the issue of the constitutionality of laws that criminalized or restricted access to abortions. The court ruled 7-2 that a right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have an abortion, but that this right must be balanced against the state's interests in regulating abortions, protecting women's health and protecting the potentiality of human life. Arguing that these state interests became stronger over the course of a pregnancy, the court resolved this balancing test by tying state regulation of abortion to the third trimester of pregnancy. Later, in Planned Parenthood v. Casey, the court rejected Roe's trimester framework while affirming its central holding that a woman has a right to abortion until fetal viability. The Roe decision defined viable as potentially able to live outside the mother's womb, albeit with artificial aid. Justices in Casey acknowledged that viability may occur at 23 or 24 weeks, or sometimes even earlier, in light of medical advances. In disallowing many state and federal restrictions on abortion in the United States, Roe v. Wade prompted a national debate that continues today about issues including whether, and to what extent, abortion should be legal. Who should decide the legality of abortion? What methods the Supreme Court should use in constitutional adjudication, and what the role should be of religious and moral views in the political sphere. Roe v. Wade reshaped national politics, dividing much of the United States into pro-life and pro-choice camps, while activating grassroots movements on both sides. History of abortion laws in the United States. According to the court, the restrictive criminal abortion laws in effect in a majority of states today are of relatively recent vintage, providing a historical analysis on abortion. Justice Harry Blackmun noted that abortion was resorted to without scruple in Greek and Roman times. Blackmun also addressed the permissive and restrictive abortion attitudes and laws throughout history, noting the disagreements among leaders in those eras and the formative laws and cases. In the United States, in 1821, Connecticut passed the first state statute criminalizing abortion. Every state had abortion legislation by 1900. In the United States, abortion was sometimes considered a common law crime, though Justice Blackmun would conclude that the criminalization of abortion did not have roots in the English common law tradition, rather than arresting the women having the abortions. Legal officials were more likely to interrogate these women to obtain evidence against the abortion provider in order to close down that provider's business. History of the case. In June 1969, 21-year-old Norma McCorvey discovered she was pregnant with her third child. She returned to Dallas, Texas, where friends advised her to assert falsely that she had been raped in order to obtain a legal abortion. However, this scheme failed, because there was no police report documenting the alleged rape. In any case, the Texas statute allowed abortion only for the purpose of saving the life of the mother. She attempted to obtain an illegal abortion, but found that the unauthorized facility had been closed down by the police. Eventually, she was referred to attorneys Linda Coffey and Sarah Weddington. In 1970, Coffey and Weddington filed suit in the United States District Court for the Northern District of Texas on behalf of McCorvey. The defendant in the case was Dallas County District Attorney Henry Wade, who represented the state of Texas. McCorvey was no longer claiming her pregnancy was a result of rape, and later acknowledged that she had lied about having been raped. Rape is not mentioned in the judicial opinions in the case. On June 17, 1970, a three-judge panel of the District Court, consisting of Northern District of Texas judges Sarah T. Hughes, William McLaughlin Taylor Jr. and Fifth Circuit Court of Appeals Judge Irving Loeb Goldberg, unanimously declared the Texas law unconstitutional, finding that it violated the right to privacy found in the Ninth Amendment. In addition, the court relied on Justice Arthur Goldberg's 1965 concurrence in Griswold v. Connecticut. The court, however, declined to grant an injunction against enforcement of the law. In 1971, Shirley Wheeler was charged with manslaughter after Florida hospital staff reported her illegal abortion to the police. She received a sentence of 2 years probation and, under her probation, had to move back into her parents' house in North Carolina. The Boston Women's Abortion Coalition held a rally for Wheeler in Boston to raise money and awareness of her charges, as well as had staff members from the Women's National Abortion Action Coalition speak at the rally. Wheeler was possibly the first woman to be held criminally responsible for submitting to an abortion. Her conviction was overturned by the Florida Supreme Court. Before the Supreme Court, Roe v. Wade reached the Supreme Court on appeal in 1970. The justices delayed taking action on Roe and a closely related case, Doe v. Bolton, until they had decided Younger v. Harris and United States v. Veitch. In Veitch, the court narrowly upheld the statute, though in doing so, it treated abortion as a medical procedure and stated that physicians must be given room to determine what constitutes a danger to health. The day after they announced their decision in Veitch, they voted to hear both Roe and Doe. Arguments were scheduled by the full court for December 13, 1971. Before the court could hear the oral arguments, Justices Hugo Black and John Marshall Harlan II retired. Chief Justice Warren Burger asked Justice Potter Stewart and Justice Blackmun to determine whether Roe and Doe, among others, should be heard as scheduled. According to Blackmun, Stewart felt that the cases were a straightforward application of Younger v. Harris, and they recommended that the court move forward as scheduled. In his opening argument in defense of the abortion restrictions, Attorney J. Floyd made what was later described as the worst joke in legal history. Appearing against 2 female lawyers, Floyd began, "Mr. Chief Justice, and may it please the court. It's an old joke, but when a man argues against 2 beautiful ladies like this, they are going to have the last word." His remark was met with cold silence. One observer thought that Chief Justice Burger was going to come right off the bench at him. He glared him down. After a first round of arguments, all 7 justices tentatively agreed that the Texas law should be struck down, but on varying grounds. Burger assigned the role of writing the court's opinion in Roe to Blackmun, who began drafting a preliminary opinion that emphasized what he saw as the Texas law's vagueness. But Blackmun felt that his opinion did not adequately reflect his liberal colleagues' views. In May 1972, he proposed that the case be re-argued. Justice William O. Douglas threatened to write a dissent from the re-argument order, but was coaxed out of the action by his colleagues, and his dissent was merely mentioned in the re-argument order without further statement or opinion. The case was re-argued on October 11, 1972. Weddington continued to represent Roe, and Texas Assistant Attorney General Robert C. Flowers replaced J. Floyd for Texas. Blackmun continued to work on his opinions in both cases over the summer recess, even though there was no guarantee that he would be assigned to write them again. Over the recess, he spent a week researching the history of abortion at the Mayo Clinic in Minnesota, where he had worked in the 1950s. After the court heard the second round of arguments, Powell said he would agree with Blackmun's conclusion, but pushed for Roe to be the lead of the 2 abortion cases being considered. Powell also suggested that the court strike down the Texas law on privacy grounds. Justice Byron White was unwilling to sign on to Blackmun's opinion, and Rehnquist had already decided to dissent. Supreme Court decision. The court issued its decision on January 22, 1973, with a 7-2 majority vote in favor of Roe. Justices Burger, Douglas, and Stewart filed concurring opinions, and Justice White filed a dissenting opinion in which Justice Rehnquist joined. Burger's, Douglas, and White's opinions were issued along with the court's opinion in Doe v. Bolton. The court deemed abortion a fundamental right under the United States Constitution, thereby subjecting all laws attempting to restrict it to the standard of strict scrutiny. Right to privacy. The court declined to adopt the district court's Ninth Amendment rationale, and instead asserted that the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or, as the district court determined, in the Ninth Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Douglas, in his concurring opinion in the companion case, Doe, stated more emphatically, the Ninth Amendment obviously does not create federally enforceable rights. Justice Blackmun's majority opinion explicitly rejected a fetal right to life argument. The court instead recognized the right to an abortion as a fundamental right included within the guarantee of personal privacy. As a result, regulations limiting abortion had to be justified by a compelling state interest, and legislative enactments regulating abortion had to be narrowly tailored to meet the compelling interests. In other words, Justice Blackmun applied a strict scrutiny analysis to abortion regulations. While acknowledging that the right to abortion was not unlimited, Justice Blackmun, speaking for the court, created a trimester framework to balance the fundamental right to abortion with the government's two legitimate interests, protecting the mother's health and protecting the potentiality of human life. The trimester framework addressed when a woman's fundamental right to abortion would be absolute, and when the state's interests would become compelling. In the first trimester, when it was believed that the procedure was safer than childbirth, the court left the decision to abort completely to the woman and her physician, from approximately the end of the first trimester until fetal viability. The state's interest in protecting the health of the mother would become compelling. At that time, the state could regulate the abortion procedure if the regulation reasonably relate to the preservation and protection of maternal health. At the point of viability, which the court believed to be in the third trimester, the state's interest in potential life would become compelling, and the state could regulate abortion to protect potential life. At that point, the state could even forbid abortion so long as it made an exception to preserve the life or health of the mother. The court added that the primary right being preserved in the Roe decision was that of the physician to practice medicine freely absent a compelling state interest, not women's rights in general. In 1992, however, the plurality of Justices Sandra Day O'Connor, David Souter, and Anthony Kennedy made a subtle move away from the physician's rights approach of Roe and toward a patient's rights approach in Planned Parenthood of Southeastern Pennsylvania v. Casey. The plurality in Casey, explicitly confirming that women had a constitutional right to abortion, and further upholding the essential holding of Roe, stated that women had a right to choose abortion before viability and that this right could not be unduly interfered with by the state. They asserted that this right was rooted in the Due Process Clause of the 14th Amendment. Prior to the decision, the justices discussed the trimester framework at great length. Justice Powell had suggested that the point where the state could intervene be placed at viability, which Justice Thurgood Marshall supported as well. In an internal memo to the other justices before the majority decision was published, Justice Blackmun wrote, "You will observe that I have concluded that the end of the first trimester is critical. This is arbitrary. But perhaps any other selected point, such as quickening or viability, is equally arbitrary." Roe supporters are quick to point out, however, that the memo only reflects Blackmun's uncertainty about the timing of the trimester framework, not the framework or the holding itself. In his opinion, Blackmun also clearly explained how he had reached the trimester framework scrutinizing history, common law, the Hippocratic Oath, medical knowledge, and the positions of medical organizations. Justice Blackmun's trimester framework was later rejected by the O'Connor-Souter-Kennedy plurality and Casey, in favor of the undue burden analysis still employed by the court. Contrary to Blackmun, Justice Douglas preferred the first trimester line. Justice Stewart said the lines were legislative and wanted more flexibility and consideration paid to state legislatures, though he joined Blackmun's decision. Justice William J. Brennan Jr. proposed abandoning frameworks based on the age of the fetus and instead allowing states to regulate the procedure based on its safety for the mother. The majority opinion allowed states to protect fetal life after viability even though a fetus is not a person within the meaning of the 14th Amendment. Justiciability. An aspect of the decision that attracted comparatively little attention was the court's disposition of the issues of standing and mootness. Under the traditional interpretation of these rules, Jane Roe's appeal was moot because she had already given birth to her child and thus would not be affected by the ruling. She also lacked standing to assert the rights of other pregnant women, as she did not present an actual case or controversy. Any opinion issued by the Supreme Court would constitute an advisory opinion. The court concluded that the case came within an established exception to the rule, one that allowed consideration of an issue that was capable of repetition, yet evading review. This phrase had been coined in 1911 by Justice Joseph McKenna in Southern Pacific Terminal Company v. ICC. Blackmun's opinion quoted McKenna and noted that pregnancy would normally conclude more quickly than an appellate process. If that termination makes a case moot, pregnancy litigation seldom will survive much beyond the trial stage, and appellate review will be effectively denied. Dissents. Justices White and Rehnquist wrote emphatic dissenting opinions. White asserted that the court values the convenience of the pregnant mother more than the continued existence and development of the life or potential life that she carries, though he suggested that he might agree with the court's values and priorities. He wrote that he saw no constitutional warrant for imposing such an order of priorities on the people and legislatures of the states. White criticized the court for involving itself in the issue of abortion by creating a constitutional barrier to state efforts to protect human life and by investing mothers and doctors with the constitutionally protected right to exterminate it. He would have left this issue, for the most part, with the people and to the political processes the people have devised to govern their affairs. Rehnquist elaborated on several of White's points, asserting that the court's historical analysis was flawed from this historical record. Rehnquist concluded, there apparently was no question concerning the validity of this provision or of any of the other state statutes when the 14th Amendment was adopted. Therefore, in his view, the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter. Political. A statistical evaluation of the relationship of political affiliation to pro-choice and anti-abortion issues shows that public opinion is much more nuanced about when abortion is acceptable than is commonly assumed. The most prominent organized groups that mobilized in response to Roe are the National Abortion Rights Action League and the National Right to Life Committee. Support. Advocates of Roe describe it as vital to the preservation of women's rights, personal freedom, bodily integrity, and privacy. Advocates have also reasoned that access to safe abortion and reproductive freedom generally are fundamental rights. Some scholars have equated the denial of abortion rights to compulsory motherhood and have argued that abortion bans therefore violate the 13th Amendment. Supporters of Roe contend that the decision has a valid constitutional foundation in the 14th Amendment, or that the fundamental right to abortion is found elsewhere in the Constitution, but not in the articles referenced in the decision. Brought to you by WikiVidi Documentaries. Would you like to know more?